Hi, it's Bill Chatt here with our weekly legal update. I'm joined today with my good friend Gus Sparagis, who's got his own practice at the law offices of Konstantine Sparagis. Gus handles both consumer and commercial bankruptcy cases, both on the debtor and the creditor side. We are obviously, as a debt collection firm, a little bit more on the creditor side. I had actually reached out to Gus earlier in the week and had proposed we'd talk a little bit about bankruptcy, since it's probably going to be an issue that's coming up a little bit more with everything that's going on with the shutdowns of COVID, with the government and all that. And Gus had been kind enough to throw at me a very interesting opinion that came out of the Northern District Bankruptcy Court. Was it this week, Gus?
I think it was April 6th or 8th, so within the last week.
Gotcha. And the judge was Deborah Thorne. And the case that Gus threw to me involves associations, condominium associations. If any of you out there in the association world know, when someone owes assessments and we start a forcible detainer process, if the if the unit owner files for bankruptcy, we have to stop what we're doing and either get a relief of stay or if it's going to be a reorg or something like that, we have to let the process play itself out. This case involves someone who I believe, Gus, had filed Chapter 7 and got a complete discharge of their debt, right?
That's correct.
Okay, so tell us a little bit about the case.
So this debtor was served with a eviction suit prior to the filing of her bankruptcy, and she subsequently filed a bankruptcy pro se, meaning on her own without the assistance of an attorney. And after going through the bankruptcy process, she obtained her discharge, and somewhat surprisingly, however, maintained her post-petition condominium association payments and continued to make them timely in the correct amount as they came due after she filed her bankruptcy. After receiving her discharge, the landlord reinstated the eviction case that they had voluntarily dismissed when they received notice of the bankruptcy filing. And they proceeded, again, against a pro se defendant now in the state court case, to obtain a in rem judgment in the amount of $17,000 for pre-petition arrears, and a $1 in personam judgment, and sought to obtain a order of possession to evict the debtor. I would guess that between that order being entered and the order becoming effective, which was 60 days, it appears she went and got counsel, and counsel filed a motion to reopen the bankruptcy case and moved for enforcement of the bankruptcy discharge provisions under Section 727, and also moved for sanctions against the creditor. I'm not sure if it was against the attorneys. I think it was just against the creditor themselves.
From what I read, that's what I saw, yeah.
So what's interesting about this case? Well, a couple of things. The first thing is, and Bill, you and I laughed and chuckled about this, but, the defense of the creditor in this case was essentially that this is how they had always done things in state court involving discharged debtors and pre-petition homeowners assessments. And that's never a good defense.
Right.
And just to back up,
It's hard to cite that,
especially when you're operating under a statutory scheme, which of course the bankruptcy code is, and in particular where, Bill, we've talked about this over the years, and creditors certainly have become much more aware and sophisticated in dealing seriously with the bankruptcy stay and its parameters and the procedures involved for getting relief. But, you know, the bankruptcy stay is a real problem for the either uninitiated or uninformed. And as a creditor attorney who's been doing this for 20 years, you know this as well as anybody else, and I'm sure that, you know, you're advising your clients appropriately, but some people don't get it. Now, in defense of the homeowners association's attorneys, to a degree, it is my understanding that certainly, at least within that office, that this was a standard procedure that they followed when somebody filed bankruptcy and then got a discharge. I'm pretty sure that there are a lot of other landlords who probably followed similar standard operating procedures. And what do I mean by that? What I mean by that is I suspect that there's a lot of landlords, whether in the homeowners association context or in the landlord-tenant context, to the extent that they were owed any debt before the debtor filed the bankruptcy, when the case is over, a lot of them just want to rush back into court, in state court, and get an order of possession because, at least in their mind, they're still owed unpaid rent. The problem, of course, with that is the discharge provision essentially eliminates, not just as a fiction, as a matter of law, the underlying liability for the pre-petition debt. Therefore, if the debtor remains current on their post-petition rent or association dues, they're no longer in default. Thus, the creditor cannot proceed with any court-ordered enforcement like the creditor did here.
And I got to say, once when you said, hey, have you read this opinion? It's like, no. And when I did, I almost fell out of my chair. I read it a little more carefully a couple times. And there's a couple things that I do want to note that, number one, to your point, there was no post-petition whatsoever due. So they had, let me turn my phone down here. They had no basis other than the pre-petition. And in fact, the court makes a point of noting that $1 that they went after, which was significant because in her pleadings, the self-represented debtor had said every penny was paid. So whether that was a little one of these from the association, or if they thought there was a reason they had to do that, but even chasing $1 that didn't exist after a discharge would be a violation of the stay, correct?
Sure.
So
I mean, I'm sorry.
The other thing is, what typically happens with the associations is this, as you well know, someone files bankruptcy. So from the point of filing backwards, that's where we're talking about the discharge, correct?
Correct.
The day after and the months coming after, any of the debts you incur, you're responsible for, correct?
Correct.
Okay. So what happens in a lot of these associations, and like you said, it was surprising that she was able to maintain her post-petition because it doesn't typically happen. Usually the person faces a pretty a bleak financial outlook, and the post-petition is an issue for them as well. And so what a lot of associations will do is they will go in and have a lift. They'll go on an motion for a lift from the stay based on post-petition. So they'll say, yes, we understand that the pre-petition debt is nothing we can discuss. However, we would like a lift from the stay, and they typically do this before the discharge comes out. We would like a lift from the stay under, I think it's section 16 of 523A.
It's 362.
Okay.
Is the automatic stay.
Right. So, but I think the opinion notes, you can get a relief from the stay, specifically for unpaid condo assessments. That's one of the exceptions. So they go in typically and they say, hey, look, we understand that the pre-petition is off limits, even though it stays as an in rem under the Condo Act. However, our debtor now is also in default in post-petition. And my experience with that is the BK judges typically, routinely grant that.
Correct.
So the BK goes on, but we go into state court then, whether or not we resume one that we had started when the BK came in, or we start new and we say, we are only looking for a personal judgment on these post-petition.
Correct.
To your point about earlier, the pre-petition does serve as a lien on the property. However, we cannot get it from the person because they've been individually discharged. Now, Judge Thorne had mentioned what they could have done on that in rem portion, the pre-petition. What did she say about that, the amount?
So as you know from handling, because we both do foreclosure work, I represent landlords and tenants and mostly commercial evictions. And so not to bury the headline, the takeaway is that, at least according to this judge, and I think she absolutely gets it right here, to the extent that a homeowners association has a pre-petition arrears claim against a debtor that has been discharged, their sole remedies to collect that liability is either A, to file a property foreclosure, I presume under the IMFL, or B, and I'm not sure this would be acceptable, but if the debtor were to sell the property or refinance the property, I think it would be acceptable that the lien would get paid at the time of the transaction of either the sale or the refinancing.
Right, because they would have to get a paid assessment letter from the association, and under the Illinois Condo Act, unpaid assessments act as a statutory lien against the property.
Correct.
So you, at the time you're at the table on the refi or at the sale of the property, the paid assessment letter would be the linchpin for the association to collect that pre-petition amount from the property, not from the owner.
Correct.
Right.
What I do like about this opinion, Bill, is the judge did not allow herself to be drawn into the murky waters of what the distinctions or differences are between in rem and in personam liability, which you and I have seen the opinions, some courts tend to struggle with, in particularly in the foreclosure area, because of course the remedy most lenders are seeking under that type of cause of action is partially in rem, i.e. against the collateral, the res itself, and then also partially in personam against the individual. Now, ironically, and it's not something that I've given much thought to, but as we're kind of talking through these things, I wonder what kind of impact this decision may have on judgments of foreclosure. I to be sure, most mortgage lenders include the individual debtor as a defendant in any foreclosure. But to the extent that they've obtained a discharge in a bankruptcy, do not proceed to obtain any kind of monetary judgment individually against the individual debtor. But some do liquidate the judgment amount and then include a statement that, they're not seeking in personam.
Right. There's a bankruptcy, they're not seeking a personal liability against the borrower.
Correct. But, I'd have to think through that a little bit further, but, this has implications, obviously, for homeowners association attorneys. It has implications for parties representing tenants and landlords under the eviction and the Detainer Act in Illinois. But, it also may have some, further reaching implications stretching over to the foreclosure area that, maybe someday will be further tested. But the takeaway is that, the short of it is, if you've got a pre-petition debt against a discharged debtor, either as a landlord or as a homeowners association, you cannot pursue that liability against the debtor, even nominally, for $1. Now, we talked about this, and I couldn't understand precisely why. I gave you my theory, precisely why they included a $1 in personam liability against the debtor in the course of the eviction. Have you given any more thought to that, or?
And I banted it around the office, and we were trying to figure out as well, because again, to the point we made earlier, $1, if it's part of a discharged amount, that's a violation of the stay. So you'd want to be careful not to do that as a practitioner, not to go after anything. I think your theory was that they couldn't have filed a eviction against the property itself. But if you mash in what we were just talking about foreclosure a few minutes ago, the lender goes after the property in foreclosure as a result of the default of the obligation of the borrower, the person. But they don't ask for the money from the person. But it all arose from the obligation of the person. They're a mandatory defendant to the case. And I'm assuming that's probably where the logic's going to lie. Here, too, I guess you would say, look, the assessments, of course, are to the property, but they're also to the owner who didn't pay. And therefore, that's why we get an in rem. Why they put $1 at all, nominal or otherwise, I can't say. I don't know.
Yeah, I for me, I think that creditor and their attorneys got off pretty lightly with, pretty much a slap on the wrist. I mean, the court, I think, assessed the debtor's costs in having to defend, which were, I think, less than $2 or $3 grand. But, you certainly could have had significantly more costs assessed. You certainly, because of that $1 in personam judgment, which, reading between the lines, I don't think you could call that anything other than improper. And I'm trying to be political about that.
Yeah.
We could think of a lot of different things to call it, but let's just call it that for now. But gee, man, I mean, that's a that I could see other courts, taking the case in a little bit of a different direction, to outright punish the creditor or its attorneys for having attempted to not just collect, but to obtain a judgment for even $1 that they knew that they were not entitled to, admittedly so.
Right. Yeah, I mean, I've gone after creditors for violating stays and got more for less of an egregious thing. Genuine mistake,
Yes.
But they did it twice, and it's like, oh, we get it. So yeah, to your point, for sure. But just to wrap it up, the one thing that we are not saying is this is not a decision or a commentary on post-petition. That's always in play.
Always.
Right.
In fact, Judge Thorne does a nice job of outlining the specific code section. I think it's at 523A16, which I think you were referring to previously.
Right.
523A16, and she went through, I think, a very nice, succinct history of the treatment.
Yeah, very well
pre and post, homeowners association dues, from the 1994 Act all the way through 2005 and what's presently pending today. And the short of it is that 523A16, and I think that this is absolute surplusage, unnecessary. It's but it basically accepts from discharge post-petition condominium assessments. So homeowners associations already have that protection. As you pointed out, in the event that there is a post-petition default, they should be running into court and getting the stay modified so that there's no question of whether they can pursue an eviction action. Because as you and I both know, evictions are inherently cheaper and more efficient by far than a foreclosure action.
And of course, in these situations, we'd assume that the debtor's probably got very little equity. So you'd have to jump a pretty big creditor with a condominium association lien of $4 or $5 or even $10,000 to liquidate the property and get your assessment, because the lender's lien comes before yours.
The homeowners association doesn't prime secured lend.
No. So when you get a mortgage, that mortgage
God.
jumps. Yeah.
Okay.
Right. That's the thing. The association's been there since the beginning of time. It was the first thing that happened. Was the association was established. It was submitted to the act.
Sure.
But and of course, this is probably a result of great lobbying, right? From lenders' lobbying efforts. So when they get it, they're first. So if you want to go ahead and foreclose your $4,000 condo assessment lien, you got to satisfy the lender. Now, to your query there, some states that don't have the condo act that we do have what is called that super lien. I think Florida is one of them. So what it is that the Illinois Condo Act is pretty comprehensive compared to other states. And we were given that little huckleberry of the Forcible Act that lets us go after someone for unpaid assessments, but we don't have to own the property. We get to kick you out. We get to put a renter in, get all our money, all our costs back. You still have to pay the mortgage and the taxes and everything else and assessments that come due, but we don't have any ownership liability.
Right.
That's what we got, I guess, in exchange for submitting underneath your primary lender.
Right. Well, that makes sense. I mean, it's a balancing. I thought that but then again, let's think about this. The homeowners association, I believe, does not need to take any other action by recording or otherwise to perfect their lien.
It's statutory. You don't need to, but I will say as a practice pointer, going forward, knowing that the only time you're going to get paid is either a foreclosure or a refi or a sale, it is not uncommon for associations to come to me and say they didn't come to us with their sale. Somehow they push a sale through and did it without a paid assessment letter. So word to the wise, for the cost of what it is to file the lien, where I would normally say don't record the lien, that I would, because it will be in the chain of title. Even though the title company should reach out and say, I understand this property is an association, we need to pay an assessment letter. It does happen. It does happen when they miss it. But once it's recorded, there it is. So
sure.
All right, Gus. Well, I want to thank you for joining me.
Always a pleasure, Bill.
Hope everything goes well with you during this shutdown, and I'm sure you're going to be busy in the weeks to come, unfortunately, for the people, but I guess fortunately for you. So, all right.
Stay safe, and I look forward to seeing you in court sooner than later.
Eventually.
Did you ever believe we would say that to each other?
Yeah, looking forward to getting back and get the ball back in the hand and getting the mound. Exactly.
That's it. All right, man. Be good.
Thanks. You too.
You got it.
Take care.